This hearing is now called to order. Public Counsel made an oral motion under Rule 53.2 of the URPR for the review of the Commission's order made on the 21st day of September 2022, refusing to stay its earlier order of the same date, refusing to adjourn these rate review proceedings. Rule 53.2 permits a party to proceedings to apply for the review of a final decision or order. The final decision or order referred to in the said rule is a reference to an order or decision which disposes of proceedings before the Commission. The term final order is to be compared or contrasted with an interlocutory order. The test for a final order is well-known application tests, which provides that whatever the outcome of the application, the matter comes to an end. The decision made by the Commission refusing to stay its earlier order or decision is not a final order or decision. Rule 54 sets out the grounds which a party must establish to justify a review or raise a question as to the correctness of the order or decision. Public Counsel did not set out the ground or grounds on which she relied despite the Commission's inquiry. Public Counsel has not identified any error of law or jurisdiction or error of fact or any change in circumstances, nor has she pointed to any new facts or facts which were not previously placed in evidence in the proceedings. Public Counsel stated that this motion raises an important matter of principle, but the important matter of principle was not identified. Public Counsel and other interveners supporting her motion argue that the practice before lower courts and inferior tribunals is to grant a stay where a party intends to move to a higher court regarding proceedings before the lower court or inferior tribunal. Public Counsel nor any of the interveners provided any authority for that position. It is settled law that a stay of proceedings is not automatic. Public Counsel did not identify the rule upon which she relied as giving the Commission the power to stay its orders or decision. However, Rule 56.1 of the URPR gives the Commission the power to stay the implementation of its orders or decisions. That discretion must be exercised on facts and must be exercised judicially, not automatic. The motion to review is denied. The Commission wishes to emphasize that unless and until there is an order of the High Court staying these proceedings, they will continue. The Commission wishes to also re-emphasize that parties are to be respectful to the Commission and to all parties. Submissions can be made and must be made without calling into question the impartiality or its perception of the Commission. If a party believes that the Commission is not impartial, then there is a place to properly litigate a claim of partiality or bias. The Commission will not tolerate any innuendo or aspersion on its impartiality or fairness in these proceedings. We will continue with the notice of motion dated September 9th, 2022, and filed by Tricia Watson and David Simpson for the Commission to order the Barbados Light and Power Company Limited to amend its application based on the Fair Trading Commission depreciation dates dated March 25th, 2022. Please be reminded that The Commission has read the motions, and therefore parties are permitted to make submissions on the motions to amplify or clarify any submissions made therein. The time limit prescribed will be as follows. Party making the motion, 15 minutes, followed by the response from Public Counsel, 10 minutes, interveners, 10 minutes each, Barbados Light and Power, 10 minutes, and the reply by the Watson and Simpson, 10 minutes. Parties will be prompted on the screen when they have 2 minutes left. I now invite Tricia Watson and David Simpson to speak on their motion.
Sir, just before you do that, I'd like you to permit me to ask a question, please, a clarification, if possible.
Yes, Public Counsel.
Thank you, sir. I realized yesterday, or even today, when you made the order that the adjournment was denied, and you've also denied the stay proceedings, I'm not sure if the order you made included denying the extension of time to file documents and to file witness statements and the extension of date of hearing. And I'm not sure if you have also said no to that. I'm not sure if I'm clear on that, because the motion was two-part. Remember, it was for the adjournment as well as for an extension of time. So I'm not sure if the whole motion has been denied.
The application was not in relation to extension of time, but it was in relation to the adjournment.
It was both.
Yes. The motion was dismissed in its entirety.
So then, sir, would we would be then putting in a motion then to be heard today about the extension of time? As I noticed, one of the matters to be discussed is an extension of time by the applicant. Sir, I would also add the applicant was present throughout all of the proceedings, and public counsel was not, sir.
Yeah. We have a number of motions to be heard today, and public counsel will be given the opportunity to raise that oral motion when we are dealing with the application in relation to time.
Thank you, sir.
Thank you, Mr. Chairman. Chair and panel, the notice of motion having been filed on September 9th, 2022 by the Watson-Simpson intervener team, we have received no proper notice of hearing of this motion. We did not receive a proper notice prior to the 21st of September 2022. We reject that a letter addressed to the Barbados Light and Power attaching a public notice is proper notice to this team that its motion will be heard. The Commission failed to follow proper procedure by not serving notice of hearing of our motion directly on us as the party filing that motion, which to repeat, in this case, that is the intervener team of Watson-Simpson, not the Barbados Light and Power, or the unnamed and unidentified members of the public. Frankly, the method used by the FTC to communicate with this intervener in respect of this motion, we have had to conclude is quite disrespectful, since we received nothing other than a cursory acknowledgement of receipt of the email and no response to the motion indicating when it would be heard. And that is a week has passed since that motion was filed. We, however, note that in deference to the Barbados Light and Power, the notice of hearing was referred to the Barbados Light and Power and not to the intervener team of Watson and Simpson. On the 19th of September 2022, this team wrote to the FTC and advised that it had not been properly served with notice of hearing, as we are not part of the Barbados Light and Power team and therefore cannot be served through the Barbados Light and Power Company. The only response from the FTC, besides that cursory acknowledgement that we have had to that correspondence to our motion, is your notice of hearing, that orally advising us yesterday that we would be heard today. However, the Utilities Regulation Procedural Rule requires that at least 2 days' notice of hearing must be given to the parties to the proceeding. That is at least 2 days before the motion is scheduled to be heard. The FTC, having only properly given that notice of hearing of the motion on the 21st of September 2022, it must now give 2 clear days' notice, counting out the 21st, the day of notice, and the day of the hearing. Today is the first day of that notice. Tomorrow would be the second day of that notice. This means that Monday, the 26th of September 2022, is the first day that this motion can be heard. Mr. Chair, it must be said that the Commission has repeatedly breached the rules of procedural propriety. The Commission has not been transparent in how it has dealt with interveners. I refer the Commission to a letter that we received on the 10th of August 2022, where we were stunned to be advised by counsel for the Barbados Light and Power that a meeting had been held between the Barbados Light and Power and the Fair Trading Commission on the previous day, and that letter of counsel stated the following.
Ms. Watson?
Mr. Chairman.
Thank you. I'm just asking you to speak to the motion that is placed for discussion.
Mr. Chairman, I am speaking to the motion because the procedural propriety and properness that the Utilities Regulation Procedural Rules mandates, it specifies that you shall give a certain amount of notice, and that period of notice has not been provided to the interveners, none of us, as a matter of fact. And that rule, Rule 8 of the Utilities Regulation Procedural Rules, also says that all of the parties to the hearing can file their responses or replies, and they are permitted to do so at least 5 days before the matter is heard. So besides the intervener party of Watson Simpson, the other parties to this matter have also been prejudiced by the Commission's failure to give the proper notice of hearing in this matter. Mr. Chairman, I think it is important that we recognize that this is a conduct that has been repeated in relation to interveners previously by the Fair Trading Commission. So the Commission proceeded to have a meeting with Barbados Light and Power during this proceeding. Chairman, if you will let me continue my motion.
Ms. Watson, I would like you to speak to your motion at hand and stop introducing other variables that are not in relation today. You would have also identified in your letter to the Commission that you're relying on Rule 11.3 of the URPR, and this deals in part with the filing of documents with the Commission and provides that documents received by the Commission after 4 p.m. on a holiday shall be considered filed by the next business day. So this rule does not provide that a document served by the Commission shall deem to have been served on the next business day. So we are saying that the notice that was served on the 16th of September 2022 at 4:32 p.m. gave the team the minimum of 2 clear days notice of the hearing of the team's application.
Mr. Chairman, I believe the panel is missing my point. For one, the commission cannot refuse to comply with the standard that it sets for all of the parties. That is one point. But the second point, Mr. Chairman, is that you did not serve notice on this intervener team. You served notice on the Barbados Light and Power by letter addressed to the Barbados Light and Power, attaching a public notice and not a notice of hearing of our motion directed to us. That was directed to us simply by oral direction of the commission yesterday, the 21st of September 2022. Therefore,
So I take it that you're not prepared to speak to the motion?
I am asking the chairman to make a ruling on whether the chairman will force us to proceed, not having been properly served with notice of motion, notice of hearing, giving us at least 2 days notice of that hearing.
It is. But we served notice on the Watson team on the 16th of September.
No, Mr. Chair, you served that on Barbados Light and Power and copied us on an email.
So we take it that you do not consider the copy of the email notice, but you were made aware that we would.
But that to this team, Mr. Chairman, and I think that this team ought to be, even if as a matter of respect, the team that filed the motion should be given a direct service that its motion will be heard in much the same way as Light and Power has received a direct notice.
So Ms. Watson, from the Watson-Simpson team, you acknowledge that you were given notice of oral notice yesterday evening. We will give you until Monday to be heard on this motion.
Obliged, Mr. Chairman.
Thank you. So we'll move to next on here. Now I gotta do these things here. Okay, so notice of motion dated August 22nd, 2022, and filed by the applicant to amend the issues list pursuant to Rule 34.7 and Rule 8 of the Utility Regulation Procedural Rule 2003 as amended. The applicant have 15 minutes to speak to this motion. Please note we are just asking for amplification and clarification as we would have read the motion.
Noted, Chair, and thank you. By procedural order dated 12th of July, the Commission issued a list of issues to be assessed in the present hearing, including number 4, Ruminal number 4D, was the issue of accountability clawback. It was issued following a procedural and issues conference held on the 4th of July 2022. A review of the transcript reveals that the Commission indicated that the conference was intended to be collaborative and that the parties' full participation was encouraged. It was also indicated that one of the main objectives was to arrive at the proposed list of issues which the parties believe the Commission should consider or not consider. This is at lines 25 to 32 of the transcript. The issue of clawback accountability was not raised in the conference by any party or the Commission as an issue which was proposed. Further, there was no collaboration as to whether or not the said issue should be considered in the application, notwithstanding the stated intention of the Commission. As such, following the procedural order, the applicant by letter dated July 25th sought clarification of this issue. By letter dated 27th of July, the Commission stated inter alia that the issue of accountability clawback refers to those requirements that were set out and approved in the 2010 rate review, but were either not implemented or are no longer being incurred by the application on behalf of the consumer. The applicant understands such clarification to refer to what is known in utility rate making as retroactive rate making. That is a situation in which a public utility sets future rates to allow a utility to recoup past losses or to refund consumers excess utility profits. If retroactive rate making is what is intended by the Commission, the applicant is constrained to resist such in light of the established authority that cautions against retroactive rate making and establishes that public utility rate making must be prospective in nature. And we reference Louisiana Power and Light Company versus Louisiana Public Service Commission. Is there a Marshall chair? I have copies of the reference decision for the benefit of the Commission. Quoted within that authority, pervading the utility rate making process is a fundamental rule that rates are exclusively prospective in application and that future rates may not be designed to recoup past losses. The rationale of this principle is that the Commission acts in a legislative capacity in exercising its rate making authority, that rate making orders have statutory effect, and that as such they are subject to the rules ordinarily applied in statutory construction. That is, we do not go back relative to the new statutory regulation. The concept being that retroactive laws are considered oppressive and unjust. The applicant understands as it relates to rate making that a clawback mechanism is an adjustment to the net capital plant reconciliation or clawback, which is used in some jurisdictions to reclaim the unspent portion of a capital budget plus the associated earnings if a utility does not spend its entire capital budget. The typical setting of such a mechanism is a so-called multi-year plan, MRP, a form of incentive rate making. The applicant, while cognizant of the Commission's role, believes that the mechanism proposed as part of the current rate hearing will result in a process which would offend against the regulatory legal principle that rates are exclusively prospective in application and that future rates may not be designed to recoup past losses. It must be highlighted that in the 2010 decision, there's no reference to clawback, neither was the applicant at any time given notice by the Commission that rates were determined or subject to any mechanism other than a rate of return rate making. The referenced interpretation does not constitute the application of a clawback mechanism. Instead, it appears to be a form of retroactive rate making and needs to be addressed as a separate and distinct issue to the present proceedings. This is especially in the context where the issue was not agreed or discussed by the respective parties, but introduced by the Commission after the issues conference. To insist that this issue form part of the hearing would offend base natural justice principles informing statutory interpretation. In addition, it is submitted that all parties will be placed at a disadvantage as they have not had the opportunity to provide the necessary evidence to aid the Commission in the determination of such far-ranging rate-making policy decision. In such circumstances, the applicant seeks the deletion of this issue from the issues list. At most, I would say, Chair, that if any sort of consideration is to be looked at in terms of amendment, there would need to be some clear directions to inform the parties such that any necessary evidentiary base could be placed before you. And that is why we consider in these circumstances a complete deletion would be better serving the uses of this rate hearing. Thank you.
I now invite the public counsel to speak on the motion.
Thank you, Mr. Chair. I don't even know where I should start because as I said before, I have not seen half of these documents. The dates to which my learned friend refers, I was not acting public counsel. So I therefore do not know how I'm expected to make any rational, reasonable contribution. And this is the very reason why, this is what we've come to, where you're asking public counsel now to comment on a motion which the public counsel cannot possibly comment on the motion. Also, I just saw a case being handed out, and I don't know if I'm supposed to read it now and then comment on it after I've read it, because this whole process then becomes unreasonable, unfair, unjust, because, sir, even if
Public counsel, we do acknowledge that you would have just received, like all of us, this is just supporting information. So I'm
But
just
sir,
asking if you're in a position to speak to the motion or
Sir,
not.
I do not have the motion, so I cannot speak to the motion.
Okay.
And half of the things being referred to in the motion, I know nothing about. So basically, it's almost ludicrous to even ask for public counsel to say anything.
Okay.
It's unfair and it's unjust because there's nothing, the principles of natural justice are again being usurped. Because, sir, you have,
But
sir, you're the one that allowed me to speak.
because on the motion, and
Sir,
the motion was served on public counsel, and the motion was also served on Barb.
The motion was served on, actually, I had a conversation, and I realized that at some point, the FTC was using, they were still, even though they were aware that there was if you want to say a new public counsel acting in the post. Can I please finish, sir? If I finish, it may make sense. If you at least allow me to finish, it would make sense. Because the point I'm making is, they were still sending messages to Alison Burke at Public Counsel's email, and no, can I not finish, sir? The point I'm making is, you've asked me to speak on a motion that, sir, you're asking me to speak on a motion, and you're not allowing me to say that I don't know anything about the motion, so I'm not understanding how you're expecting me to speak on something I know nothing about. That's the point I'm making, which goes back to the very beginning of everything when I was first saying to you that I came into this post on the 19th of September, 2022.
Yes, public counsel, we were made aware through your motion that you assumed the office on September 19th. Public counsel, we do recognize that the issue is not with Ms. Dean, but the office of public counsel. And the office of public counsel, who would have been representing the ministry, and Barb, both the Ministry of Energy and Business Development and Barb, who are interveners in this process, was served with the motion. So we are speaking to the office of public counsel and not to Ms. Dean.
All I will say is that it's impossible to speak on a motion that I know absolutely nothing about, sir.
Thank you. Okay. So the Barbados Renewable Energy Association.
Thank you, Chair. We see this as a legal issue which we know nothing really or will be able to have any comment on. So thank you for the opportunity.
The Energy Division, Ministry of Energy and Business Development, Ms. Cummins.
Yes, thank you, sir, and panel again. Inasmuch as my learned colleague, Mr. Aline, had indicated that the clawback was not part of the original issues list, and he's calling that it be that be acknowledged and it no longer should be discussed. The fact that the commission saw it as an issue, and he has acknowledged, that is Mr. Aline, that we can either be given the opportunity to review and make our submissions thereon, or he would rather that the commission take this issue off delete this issue off the list. I will hereby say that I agree with the position that the interveners be given the opportunity to look at this issue and address it accordingly after having sufficient time to do so.
Okay, thank you, Ms. Cummins.
Thank you.
Ms. Watson and Mr. Simpson.
Thank you, Mr. Chairman. I would refer the panel to Rule 8 of the Utilities Regulation Procedural Rule, in particular Sub-Rule 2, which commands that a notice of motion shall, among other things, be accompanied by any documents that may support the motion. We were just served with a precedent that the company is seeking to rely on. The company filed this motion on the 22nd of August, a month ago exactly. They were also given notice on Friday, in as much as the letter was addressed to them, but comes to this forum to serve us with supporting documents, having given no notice of these supporting documents and expecting us to reply. This intervener team, in addition to thinking that that is highly inappropriate, we seek leave to consider the document that has been filed on interveners and the commission today, and seek that the hearing of this motion be adjourned accordingly. The panel giving appropriate time for the parties to consider the additional information that's been filed in the motion. That's my submission, Mr. Chairman.
Okay. Thank you, Ms. Watson. Mr. Went.
Thank you, Mr. Chairman. Again, I would not be looking at any legal aspects in my submission, but I'd like to say that it's established practice that ratepayers must always be able to given the opportunity to see how prudent the company has been. And what we've discovered so far in the non-consolidated financial statements and some of the other documents that we've been able to review, we're still going through them, but there's some fundamental things that have taken place that we really need to look at, and we believe, our team believes, that the Commission is well aware of some of those matters, and that is exactly why the Commission made the ruling as it is. And what are some of those issues? Light and Power has said that in the last rate hearing that it was going to introduce low-speed diesel equipment that would allow ratepayers to save $30 million at an oil price of US $60 per barrel back then, and it meant, therefore, then that was not done. Ratepayers have a right to look at that. We also have a situation where we know in 2019 that the government has actually changed the corporate tax policy, and I think Light and Power might probably have an effective tax rate of around 15%, and that probably came down to approximately 2.34%, using a sliding scale of anything about 5.5 to 1%. We believe these are matters that the Commission recognizes have to be examined. In addition to that, we are aware that on the self-insurance fund, there are changes that were made and that we have seen so far. So we want to be able to look at that, and if necessary, the Commission deems appropriate, will make the appropriate adjustment, and it could have been the other way around. So we do not support this motion and believe strongly that the commission is right in its position to be able to examine these matters. I would like to have a little bit more to say about this at a later time, but we do not support that motion at all. Thank you, Mr. Chairman.
Thank you, Mr. Wench. Lieutenant Colonel Brown from the Barbados Sustainable Energy Cooperative Society Limited.
Thank you, Mr. Chairman. We strongly condemn this motion. As a matter of fact, Mr. Chairman, we would like to commend the FTC for adding this item to the list of items to be discussed. I would like to make the point, sir, that the item that has been added is actually accountability clawback. Counsel for the applicant went to great lengths to explain why retroactive rate making may not be appropriate. Sir, these are completely different things. Accountability clawback is about accounting for responsible decisions that should have been made in the past. And we're talking about, sir, about a situation where the last time the Fair Trading Commission and the public had a close look at the operations of this company was in 2010, sir, when the decision was made. This is now 2022, 13 years hence. Many things have happened in the interim, sir. And for a company's representative to come with an argument that everything that went on in those 13 years is now dead and gone, and we must forget that because of something he's calling retroactive rate making, so has to be laughable. What the commission actually added to the list is related to accountability for decisions that should have been taken in the interest of the public, that they were properly taken and properly accounted for. I like the word accountability, so I strongly and reservedly compliment the FTC for adding that to the list. I must tell you, sir, that my constituents will be absolutely upset if it is removed. And I think, sir, that note should be taken of the fact that the arguments skillfully put forward by legal counsel for the applicant has nothing to do with accountability. He is arguing about retroactive rate making. The council is not suggesting anything about retroactive rate making. So I therefore, sir, support Mr. Wench's position, and I strongly disagree with the motion. Thank you very much, sir.
Thank you, Lieutenant Colonel Brown. The applicant reply.
Thank you, Chair. Just two issues, and more relative to clarifying the record. Intervenor Wendt would have listed a number of matters which he believed reasonably should be considered in the context of this hearing. All matters that he has raised have been made the subject of interrogatories and have been extensively spoken to by the applicant. And let it be made clear that those issues we understand will be the subject of these hearings and will be explored. And we imagine that Intervenor Wendt will do his utmost in terms of getting the information that he requires. We are in no way opposing the discussion of those matters. They have been dealt with substantially in the interrogatories. On the issue of clawback and what is stated in the issues list, as I indicated, we sought clarity from the Commission. The Commission indicated what it understood it meant by those terms, and the submissions that I have made refer to the explanation that all parties received as to what the Commission considered accountability clawback. Thank you.
Thank you, Counsel. So we'll move on to the next motion because we would hear all the motions and then we would adjourn to consider the submissions. So the next motion is a motion dated September 16th, 2022 and filed by the applicant to amend procedural order dated August 26, 2022 to permit the Barbados Light and Power Company's expert witnesses to virtually participate and give testimony in the hearing of the application pursuant to Rule 8 of the Utility Regulation Procedural Rules as amended. Applicant?
Thank you, Chair. This issue arises out of the referenced change in original considered hearing dates. On the basis of the initial indication from the Commission, the applicant, as would have been normal and the practice, would have engaged their consultant and experts who were given testimony to make them available for the in-person hearings. With the ruling coming out of the hearing on the 22nd of August, it meant that we had to revisit the experts who had tendered their information and request their renewed availability based on the new tender dates. A number of the experts indicated they had prior commitments that would have been booked, with some of the experts doing presentations in other jurisdictions that would have been booked prior to our request. In the circumstances, we felt it necessary to file this motion and make the request. Obviously, this motion facilitates all interveners and the Commission having the opportunity to cross-examine and test the experts on the testimony that they have already filed. And in the circumstances, we believe it is only fair in the process. It is in line with the concept of not delaying the hearing, but getting it going, while allowing all the parties and the Commission to have the benefit of cross-examination and testing of the filed testimony. We note that this request has also been made by intervener Wendt, and we would certainly agree it. And I think it is a request and a motion which facilitates expedition and efficiency in terms of the hearing. Thank you, Chair.
Thank you, Council. Public Counsel.
Thank you, Chair. I have no objection to allowing a virtual, to allowing his consultants to appear virtually. I have no objection to it. And I trust that when my turn comes to ask the same question, it would be allowed as well, sir.
Thank you. Barbados Renewable Energy Association.
Thank you, Chair. We see no reason why this should not be allowed, not only to Light and Power, but to anybody that has difficulty as a result of the changes, or anything that may come up since then that may prevent them from attending, but still be in a position, would like to be in a position to present evidence, and I think it could only add value to the overall hearing. Thank you.
Ms. Cummins from the Energy Division, Ministry of Energy and Business Development.
Thank you, Chair. I too lend support and agree to this motion. I would just like to go a little further. I think Mr. Worm went there, but he didn't take it right down to the end. But I would like for whatever decision that the Commission makes, that it would allow all parties to this hearing to be permitted to have their witnesses join virtually, as the case may be, because of whatever reason. There was one other thing I wanted to say, I can't remember. Yes, and also noting that I also agree that to do virtually would also serve natural justice. It would allow persons to be able to present their cases in totality. There would not be any prejudice, because as much as we spoke earlier on behalf of public counsel, we are fair people and would not wish the applicant to be prejudiced by not being able to present all of its witnesses to give the evidence and for them to be challenged or ask for clarification. And that also should be the position for any intervener. And I also believe it will help in the expedition of this hearing. Thank you, sir.
Thank you, Ms. Cummins. Okay. Ms. Watson and Mr. Simpson.
Thank you, Mr. Chairman. The intervener team of Watson Simpson does not find the request to be unreasonable, the motion, and we are in agreement with granting the company leave to introduce its witnesses by virtual meeting and the additional requests, provided, of course, Mr. Chair, that that is extended to all parties, whether they have already made such a motion or makes such a motion in the future. Thank you, Mr. Chair.
Thank you, Ms. Watson. Mr. Wayne?
I'm having some problems sometimes with the mic, Mr. Chairman, so please forgive me. Thank you for giving me the opportunity again. We support this motion, and as you know, we've asked that Light and Paul, who has requested that their expert witnesses and, other consultants be allowed to virtually participate. We've got Dr. Ali Elfar, who is now heading back to the US from Egypt, and we would welcome this opportunity. What we would also like to say is that, like Ms. Cummins said, that it could be at times when some person, for whatever reason, may have to give testimony, even in this group, virtually, and would like to ensure that that is accommodated. We also believe that the whole question of costs could probably also benefit, because you can imagine your travel and stuff like that. So from our side as well, and the general cost of the hearing, we believe this is the thing to do. So we wholeheartedly support the motion and would like to join with Light and Paul in asking the Commission to approve it. Thank you.
Thank you, Mr. Wayne. Lieutenant Colonel Brown?
Thank you, Mr. Chair. We fully support the motion. As a matter of fact, we would like to suggest, sir, that given the changes in the technology recently, that this be a permanent situation where experts are available online. That way, sir, even the poor cooperative coalition could afford to have experts intervening in the process, sir. And it could only redound to the betterment of the overall process. So we fully support the motion, sir.
Thank you. Applicant?
Thank you, Chair. I have nothing further to add.
Thank you. Okay. We move on to the motion where the application dated September 16th, 2022, when filed by the applicant, to permit the applicant to give evidence via a witness panel in the hearing of the application pursuant to Rule 21 of the Utility Regulation Procedural Rules 2003 as amended. The applicant.
Thank you, Chair. As you indicate, this application comes further to the powers of the Commission under Rule 21. Again, it is an application which is made in terms of the interest of efficiency and time saving. Both Mr. Seal and Mr. Graves worked on the drafting of the capital expansion memorandum and supporting schedules which form part of the applicant's rate review application. In addition, both gentlemen have provided and contributed to responses relating to the interrogatories that touch that memorandum. The Commission has set a limited number of days relative to this hearing, and there are multiple parties that must be considered. In the circumstances, we are asking the Commission to revise its return to its previous precedent, which was as recent as July 1st, 2022, when it allowed the witness panel of Mr. Roger Blackman and Mr. Ricardo Jennings to give their testimony. And we consider that a witness panel of these two individuals will assist in terms of efficiency and time saving. And as such, it's on that basis that the application is made. The second requested element of the motion related to an extension of time pursuant to the commission powers. And this relates to the witness statements that were filed pursuant to the rules as required in terms of any witness who intends to give oral testimony before the commission. On this occasion, the delay that we are referencing was 1 business day after the deadline, and the witness statements were filed as soon as reasonably practical. The most important aspect of it is that the substantive written evidence of all these witnesses has already been filed and has been before the commission for many, many months. This is a technical obligation under the rules in terms of the witness statements. And as such, there has been no prejudice to any intervener or the commission in relation to the substantive evidence that any of these witnesses will be providing for the purposes of this hearing. Obviously, the commission is aware that Rule 7 grants the commission this power to extend the time limits. This can be done on its own motion or initiative, or where a party has need to request such a ruling. In the terms of the very limited nature of the breach of the time element, and in terms of the fact that there's no substantive prejudice to any party, and there is no new evidence within the witness statements that have been filed, we request that the extension of time be granted as requested in the motion. Thank you.
We note you have spoken to 2 motions.
My apologies, Chair. I believe they were filed as one, and I just dealt with them as they were filed. I didn't know you intended to break them up. My apologies.
Yeah. So we just would ask the interveners and public counsel that they can so reply to both in their submissions. Public counsel?
Thank you, sir. Both requests appear to be reasonable and just because it would be more efficient, and we're all about efficiency and reasonableness. So the public counsel has no objection to the motion.
Thank you. Barbados Renewable Energy Association?
Thank you, sir. We support the motion for the same reason as the public counsel.
Okay.
Thank you.
Thank you. Ms. Cummins?
Thank you, Chair. I also concur with the statements made before, and I too have no difficulty with the order being granted.
Okay, thank you. Ms. Watson, Mr. Simpson?
Thank you, Mr. Chair. We have no difficulty with the request set out in the motion. In relation to the motion for extension, well, for both motions, should any other party wish to have evidence given by panel or requesting a similar extension for filing of witness statements, we would ask that the commission give similar consideration to any party making that request. Thank you.
Thank you. Mr. Wendt?
Thank you again, Mr. Chairman. This is actually a relief for me because on the 18th of August, Mr. Chairman, you would have received correspondence from Ms. Cheyenne Ince written to Mr. Webster in an affidavit filed by Mr. Blackman, which in making reference to procedural order number 5 dated 22nd of June 2022 and procedural order number 1 of the commission dated July 12th, and among other things indicate that 1, that PDF 5, Direction 5 and procedural order 1 the Commission set certain timelines for issue of interrogatories by parties to the application for the issue of further interrogatories. 2, that Procedures Order 1 provide a deadline of July 29, 2022 for the interveners to pose interrogatories to the applicant. On or about the 5:37 p.m. on July 29, 2022, BLPC received further interrogatories from an intervener, Mr. Went, and his team. And these further interrogatories of intervener Mr. Went were in breach of the timeline established by Procedures Order Number 1. And these further interrogatories of intervener Mr. Went were served directly on BLPC in contravention of Procedures Order 5. As per that note above, the further interrogatories were filed on July 29, 2022. However, we accept that our letter of the July 2029 was filed by 5:37 p.m. or 1 hour and 37 minutes after the FTC's deadline of 4 p.m. We have been experiencing technical glitches from time to time, and on the 29th of July 2020, we were pushing to file before 4 p.m., but we just couldn't make it. We do not have the administrator's assistance. We do not have the secretarial support. We do not have technical support. Further, we have our jobs and other priorities, which meant that late nights and weekends have to be spent reviewing, analyzing voluminous documents to provide meaningful response to our requests, additional information to get a better understanding of the pertinent issues and the facts. On the said July, we opted to give all parties insight of our further interrogatories submitted to the FTC, bearing in mind that the public hearing at that time was set for August 29, 2022. Our intention was not to contravene, Procedures Order Number 5, but rather to make the information available for review as early as possible. Further, we felt that such an approach would avoid duplication if other interveners had similar requests. And that's the response that we sent to the Commission. So it pleased me today to support Lightning Paul because we want to make sure that this process is run in a way that is fair to all parties. And equally in saying that, I would like, Mr. Chairman, to say that this is exactly why we support the move of the Public Council, because we all here, in spite of what the law says, we want the spirit of the law. So we fully support both requests. Thank you, Mr. Chairman.
Thank you, Mr. Went. Lieutenant Colonel Brown.
Thank you, Mr. Chairman. We have no objections to both motions.
Applicant, you wish to reply to?
No further response, Chair.
Okay, thank you. The last motion is a request for confidentiality submitted by the Barbados Light and Power Company Limited. But in order to deal with a hearing in the absence of the public, pursuant to Rule 39.1, the Commission has the discretion to and has determined to hold this confidentiality hearing in camera and in the absence of the public, since the Commission is of the opinion that circumstances so warrant and matters involving public security may be disclosed. All parties present should have submitted their respective executed declaration and undertaking documents to the Commission. The criteria, in accordance with Rule 13.9 of the URPR, in considering the applicant's request, the Commission will apply the criteria set out in Rule 39 of the URPR. The burden of satisfying the Commission that documents should be held in confidence will be on the applicant. The Commission will therefore examine the applicant on the contents of its written submissions and oral submissions. Interveners will be given the opportunity to object to the applicant's request, and the applicant will then be allowed to respond. So we need to ensure that persons in the room would have signed the necessary declaration and undertaking documents. The streaming will be discontinued and the hearing will be held in camera.